Hello guys, welcome to my channel. The Lazy is more. So today we are discussing not an editorial but frequently asked question, and in that there is one new topic, that is data protection bill, and it is also important from our mains point of view. Data protection bill of 2023. We may have discussed before the draft legislation. Okay, so let's start these frequently asked questions directly. So the title of this topic is, what is the data protection bill of 2023? How is the Digital Personal Data Protection Bill 2023 different from its previous iteration? What are the domains where it has made advances and the ones where it is lacking? The story so far. The journey towards the data protection legislation can be tracked back to 2017, when an expert committee was constituted by the Ministry of Electronics and Information Technology. The major development came in December 21, when the Data Protection Bill 2021 was released. However, it was withdrawn in Parliament by Minister for Communication and Information Technology Ashwini Vaishnaw on August 3, 2022. On November 18, 2022, a draft of the Digital Personal Data Protection Bill 2022 was released for public consultation. The submission made under this consultation process were not made public. The request to publicly release the submission was also denied in a right to information application. 1 year on, the 2023 bill has been tabled in Parliament without clarifying how and what basis these changes were incorporated. Who does it protect? In the first, the new bill introduces duties and penalties on a data principal. Clause 11 of Chapter 3 states that the data principal has the right to request from the data fiduciary a summary of the personal data being processed, identities of all the DF with whom its personal data has been shared, and so on, subject to a few exceptions. Under Clause 12, users can seek correction, completion, update and erasure of their personal data. Interestingly, the provision which allowed a DF to reject this request has been removed. So here users have also been given the right of grievance redressal and the right to nominate another individual in the event of death or incapacity to exercise their rights. While the impetus for a data protection legislation must be to protect a DP's personal data from being unwittingly exploited, the bill appears to be designed in a manner that this protection is compromised. Interestingly, the bill further goes on to impose duties and penalties on the DP. To exemplify the above, Clause 15 Clause D of this chapter states that the DP must ensure not to register a false or frivolous grievance or a complaint with the DF or the Data Protection Board, and failure to adhere with this may enable a penalty of 10,000. This is an onerous obligation which may effectively prevent a DP from raising grievances. Who does it exempt? Data breaches are becoming regular occurrence. It was reported in June 2023 that a major privacy breach with respect to the CoWIN portal had taken place, and personal details of vaccinated users had been leaked on Telegram. Recently, in July 2023, about 12,000 confidential records of State Bank of India employees were reportedly made public on Telegram. In view of this, a cause of great concern that arises in the bill is the exemption under Clause 17 Clause 2, which, if notified, is granted to the government and its authorities. On 5 specified grounds, the bill exempts the government authorities as notified, marking a discernible expansion of the scope of exemption. Personal data which is processed for research, archiving or statistical purpose will also be exempted under Clause 17, Clause 2, Clause B. While previous iteration of the bill also provided exemption, this has now been broadened to state that data processing undertaken by the Union government on information provided to it by an exempted instrumentality will continue to remain exempted from the purview of this law. What does it seek to amend? The changes that the bill seeks to implement by way of Clause 44 are significant. For instance, Section 43A of the Information Technology Act 2000 imposes an obligation on corporates to award damages to affected persons in case of negligent handling of their sensitive data. Clause 44, Clause 2 of the bill aims to exclude the application of Section 43A, thereby rendering an individual who has suffered breach of their data without any relief. Clause 44, Clause 3, which seeks to amend the entire Section 8, Clause 1, Clause J of the Right to Information Act 2005 and replace it with information which relates to personal information, has received heavy criticism from stakeholders. Previously, qualifiers existed which narrowed the information that could be withheld by the public information officers. Now the removal of has no relation to any public activity or interest or which would cause unwarranted invasion of the privacy of the individual widens the scope of the withholding information. Does it protect users? A widely appreciated departure from the previous iteration is the DF's obligation to notify the DP in case of personal data breach. Other obligations imposed on DF include notifying the DP about the purpose for which their data may be processed and the manner in which they may make a complaint to the DPB, withdraw consent, and seek grievance redressal. However, as discussed before, there is deviation from DPB 2021 with removal of the provision for compensating a user affected by personal data breach. In further departure, Clause 5, which outlines notice obligations on DF, does not mandate them to inform DPs about data being shared with third parties, duration of storage of data, and the transfer of data to other countries. Lack of obligation on the part of DF to notify DP at the offset makes the DP's right to obtain information pertaining to their personal data perfunctory. The assumed consent framework of DP-DPB 2023, on the other hand, remains unchanged. In place of using the term deemed consent, which was present in DP-DPB 2022, Clause 7 uses the term certain legitimate use, which outlines the various situations in which personal data may be processed. Without obtaining the DP's informed consent, the DP-DPB 2023 fails to differentiate between personal data and sensitive personal data, consequently negating the elevated level of protection associated with the latter. Chapter 5 and 6 deal with the DPB, which is the primary authority for ensuring that DP-DPB 2023 is upheld. DPB's independence has also been in question since the 2019 version. DP-DPB 23 mandates all its members to be appointed by the Union government. A favorable evolution is the clarification that salary, allowances, and other terms of service of DPB members cannot be varied to their disadvantage post-appointment. However, only adjudicatory and not regulatory powers have been bestowed upon the DPB. So, this was for today, guys. I hope you would be understanding, and please let me find out the 5 new words that I will use, and I would also recommend you to find out and comment in the comment section. First is data principle, that is DP. Second is data fiduciary. Third is impetus. Render. Compromise. Okay, so these are the 5 new words for today, and please do comment in the comment section the new words that you find favorable for your writing as well as conversation, so that you can use it in your daily conversation as well as writing. Okay, so this was for today. See you guys till then. Bye bye, signing off for the day.